Good morning, everybody.
With the leave of the court, may I mention item 26 and 27 from the daily cause list. I sent an adjournment request. Also inform Mr. Pasari.
This is the same refund matter.
Yes, a similar matter had been decided earlier. We had filed a counter affidavit just yesterday in the Dropbox.
So I'm appearing for the petitioner in this matter. Since a counter affidavit in one of the cases was served yesterday, my rejoinders are ready, but it will be filed by tomorrow or day after, man. Because the person concerned has to come and sign it. So it will be filed, man. All that I'm praying it, let it come in the next week, man. There is no difficulty. We'll take it up.
Yes.
Very well. And counsel for the respondent, Mr. Sarona Mittal, submits that counter affidavit has been filed in the Dropbox yesterday. This may not come on record by now. Stop. Therefore, a prayer for adjournment has been made. Suppleant counsel for the petitioner, Mr. Pasari, also submits that matter may be adjourned for next week so that he may file rejoinder thereto in the meantime. As prayed for by learned counsel for the parties, let the case be passed over for the day.
Much obliged.
My lord, may I mention serial number 6, my lords? I had circulated an adjournment request, my lords, in this matter. This is a tax appeal where I am appearing for the respondent department, my lords.
Yes.
My lords, with consent of the appellant, my lords, Mr. Pasari is appearing in that matter, my lords. I was praying for 2 weeks' time, my lords, in that matter.
You have to file some counter affidavit.
My lords, I have to file counter affidavit, my lords.
And counsel for the respondent, income tax department.
I am appearing for the appellant. Can I make a request that the matter may come up in May? Because the appeal filed by the appellant with regard to criminal prosecution, which is the reason why this tax appeal has also come, that is fixed for April last week, Manoj. So that will have a direct bearing.
Submits that prays for further 2 weeks' time to file counter affidavit. Stop. Then counsel for the appellant, Mr. Nitin Kumar Pasari, submits that the matter may come up in the month of May, as the criminal prosecution is likely to be over by end of April, which is related to the present proceedings.
Yes, Manoj.
As prayed for by the counsel for the parties, place the case in the first week of May 2022.
Much obliged, my lords.
Joint permission, may I mention minutes?
Yes.
Minutes I'm mentioning for serial number 2 at daily board minutes. Minutes we have received the reply minutes. We are seeking some time for filing rejoinder minutes.
To defective में आगे है गलती. Then counsel for the petitioner, Mr. Avinash Poddar.
Please minutes.
That counter affidavit has been served upon them. The matter may be adjourned for short while so that he may file reply thereto. As prayed for, the matter will be listed after 1 week.
Please minutes. I'm obliged.
I fear for the statement.
May I mention serial number 12, my lord, from the daily cause list?
Yes.
Although,
my lord,
I am
on behalf of Mr. Ranjit Kushwaha, if I may be permitted to. My lords, on behalf of Mr. Ranjit Kushwaha, if I may be permitted to state something on serial number 12.
Yes, my lord.
So Mr. Ranjit Kushwaha was also saying something.
Yes, my lord. I am led by my senior Mr. Hardik Bora, my lord, in this case. So he may be permitted to this, my lord.
Yes, Mr. Bora.
My lords, in this case, garnishee notices has been stayed pending the appeal before the commissioner appeal and stay granted as per section 107 of GST Act. Now the appeals has been decided in my favor. So, my lords, that interim order may become absolute and matter may be disposed of, my lords. That's the only request, my lords.
The difficulty is that those appellate orders have not been brought on record by way of any affidavit. They have been sent through mail yesterday, perhaps.
Yes, my lords.
Yes,
So you file an affidavit and bring on record those documents, and whatever you have to make a statement, say in the affidavit.
That will be done, my lord. So 15 days time may be granted so that I can send it through from Jaipur to the place.
And counsel for the petitioner, Mr. Hardik Bora, assisted by Mr. Ranjit Kuswaha, and counsel on record submits that during pendency of this petition, where the garnishee orders have been stayed on account of pendency of the appeal by the petitioner, the appeals have been decided in two appeals were there.
Two appeals were there.
Both the appeals have been decided in favor of the petitioner under section 107 of the JGST Act. So, though he seeks to bring on record the appellate orders by way of an affidavit. Stop. You could have done it today also. Anyway.
In fact, yes, my lords, it's some defect from my side for the reason that I have sent affidavit to the Jharkhand from Jaipur. However, the person has wrongly signed from Jaipur. I am sitting at Ahmedabad, so I could not verify it. So I would again send it the fresh affidavit. That's the difficulty, and that's why I could not place it on record today, my lords.
He further submits that in the event of the appeals being allowed in his favor, in petitioner's favor, the interim order staying garnishee proceedings may be made absolute. Stop. As prayed for, list the case on 6th April 2022. Affidavit should be on record before the next date.
My lords. Deeply obliged, my lords.
much obliged.
Yes.
From the supplementary list, under the heading for orders, item 1 WPT number 4566 of 2021, Mr. Salona Mittal for the petitioner, Mr. P.S. Pati for the respondent.
Yes, sir, sorry.
In view of the aforesaid discussion and judicial pronouncement, it is held that Section 1889 of JVET Act is not applicable in the case of the petitioner. Consequently, the instant writ application is allowed and the judgment and order dated 28/7/2021 passed by the Learned Commercial Tax Tribunal in GR 7 of 16, Annexure 6, order dated 19/10/16 of the Joint Commissioner Appeal passed in appeal case number so and so, Annexure 3, and also assessment order passed by respondent number 2, where the input tax credit amounting to 1598,658 was disallowed, are hereby cost and satisfied.
Obligement.
I agree.
Much obligement.
Obliged.
from the daily cause list under the heading for orders with defect, item number 1, WPT number 4899 of 2021, Mr. Vikas Pandey for the petitioner, Mr. Rahul Sahu for the respondent.
But I am for the petitioner in this matter, Lord sir. I bring
Yes.
for 1 week time for removing the surviving defect, Lord sir.
1 week time is spread for Mr. Rakesh Sharma for petitioner, Mr. Rahul Sahu.
Obliged, my lord.
Much obliged, Lord sir.
For orders, item number 3, first appeal number 277 of 2018, Mr. Manoj Kumar number 4 for the appellant, Mr. Lalit Yadav for the respondent.
Lordship, Lordship, I appear on behalf of the appellant's Lordship. I file a substitution petition, Lordship. The respondent number 5 is died, Lordship.
Who are the legal heirs?
लीगल ईयर्स लॉर्डशिप एक वाइफ है लॉर्डशिप और एक लड़का है जो रेस्पोंडेंट नंबर रेस्पोंडेंट एडवोकेट जो हमको जानकारी दी लॉर्डशिप.
Deceased respondent is Jagdish Mathur.
नहीं लॉर्डशिप, धनेश्वर यादव इज डाइड.
Dhaneshwar Yadav. Okay, Dhaneshwar Yadav. In order to substitute the deceased respondent number 5, Dhaneshwar Yadav, substitute the respondent number 5, Dhaneshwar Yadav, who has died during pendency of this appeal. IA number 1977 of 2022 has been preferred for his substitution. Stop. Let notice issued under registered cover and ordinary process upon the proposed legal heirs named under para 7 of the instant IA, who are said to be the wife and son of the deceased respondent number 5. Stop. Requisites be filed within 1 week.
No lordship, 2 weeks time may be given lordship.
Within 2 weeks, dealing with this appeal shall stand dismissed without further reference to the bench as against the proposed legal heirs.
Lordship, only for the IA petition may be filed lordship. Register post IA का नहीं लॉर्डशिप खाली जाएगा लॉर्डशिप नोटिस में.
Let the IA only. इसीलिए तो 1 week कर सकते थे.
अच्छा ठीक है लॉर्डशिप. I am much obliged my lord.
Very well.
For admission, item 4 TA number 58 of 2019, Mr. Rahul Lama for the appellant, Mr. Man Kumar Chaudhary for the respondent.
Malaj, we are withdrawing this appeal, Malaj, because of the tax effect. Malaj, we were only praying that liberty may be given to us to move before the tribunal.
This is also that interest.
234, yes, Malaj, section 234B.
Then counsel for the appellant, Mr. Rahul Lamba, seeks permission to withdraw this appeal on instructions, as the tax effect of the disputed amount is less than the monetary limit of preferring the appeal before this court in terms of the CBDT circular number 23 of 2019. Stop. However, he seeks liberty for the appellant to prefer a review petition before the Income Tax Appellate Tribunal in respect of the issues relating to levy of interest. Stop. Liberty is granted to the appellant to do so if permissible in law. Stop. However, in view of the prayer made by the appellant, on behalf of the appellant, the instant appeal is dismissed as withdrawn. For the respondent, Mr. Kiran Poddar and Mr.
Yes, my lord, I'm obliged.
Much obliged, Manoj.
Mr. Poddar, you have succeeded in that NG products matter from Supreme Court.
Yes, my lord. The day before yesterday, the judgment came, my lord.
What about the other two appeals which we had decided earlier?
Other two appeals, to my information, those persons did not move to Supreme Court, my lord.
Oh, achha, achha.
They did not move.
In your case, since the work had been executed to a considerable extent, perhaps
Yes,
that
yes.
is why the Honorable Court was
Yes.
more inclined. Our
And my lord,
difficulty
the
was-
Honorable Supreme Court has said that even if there is some arbitrariness also, then the agreed party must be sent to civil court for filing recovery of damages, etc. But the exercise of power under Article 226, these tender matters should not be entertained. Otherwise, it will delay the execution and it is against the public interest. This is what the Supreme Court has observed.
injunction or stay should not be granted. That
Yes.
is what the single judge. I also went through it yesterday. Very well. Yes.
Item 5, TA number 3 of 2020, Mr. Piyush Pradhan for the appellant, Mr. Rahul Lama.
Yes, my lord. Page 21 may kindly be seen, that is the substantial question of law involved in this appeal, my lord, this appeal. Page 21 of memo. Whether under the facts and circumstances and in law, the tribunal is justified in confirming the addition of rupees 9,61,984 credited in the three bank accounts of the appellant, being the amount deposited out of total receipt of rupees 21,69,320 from petty civil construction work, especially in view of the fact that the tribunal accepted, believed, and brought to tax the net amount of rupees 2,16,692 at the rate of 10% disclosed by the appellant under section 44 AD of the Income Tax Act 1961, arising out of the said petty civil construction work. My lord, I have quoted section 44 AD at para 18 of memo, my lord. That will, my lord, will find at page 18.
This appeal shall be heard on the following substantial questions of law. Page 21 and 22, Roman para 1, 2 and 3. Stop. Call for the lower court records from the ITAT Ranchi, bench Ranchi in connection with so and so. Stop. For the respondent, Mr. Rahul Lama.
Item number 7, WPS number 177 of 2020, Mrs. Reena Mukherjee for the petitioner, Mr. Gautam Rakesh.
I pray for short time, my lord. The senior counsel, Mr. Temple, is on legs in another court, my lord. Short time after one or two cases.
Rejoinder has been filed. You have taken
12:39.
Rejoinder has not been
Not filed.
Rejoinder has not been filed. You had taken last indulgence. Tell us, you want to file rejoinder or you have already filed it or you do not want? He's not aware.
I am for the respondent in this case, my lord.
Respondent के तरफ से
question. Oh, sorry, I didn't further respond. Yes, my lord, I have to. Yes, my lord, sorry, I am the petitioner in this case, my lord.
So you have not filed the rejoinder. You had taken time by way of last indulgence on 8th March.
Don't the file. Yes,
It was only one registration which was like the precedent. ठीक है, pass over.
password for the day, my lord. Then password for the day, my lord.
Every time we come prepared and you are getting it adjourned. Pass over for the day.
Item 8, WPT number 4249 of 2020, Mr. Mohammad Zaid Ahmed for the petitioner, Mr. Ratnesh Kumar, Mr. P.S. Pati for the respondent.
Your Lordship, in the instant case, I am praying for 10 days time, Lordship. I had also sent a mail yesterday. As Your Lordship, in this case, appellant wants to engage another lawyer for arguing the case, Your Lordship.
1 year has passed.
Your Lordship, we want to engage.
This matter.
Only 10 days after any date may be fixed, Lordship. After 10 days, he will do the needful.
Maloj, I appear for the respondent state, Maloj. May I indicate one thing, Maloj? Maloj, in this case, the primary dispute is with regard to that GST ITC 1 could not be uploaded on the portal because of certain glitches. Now, Maloj, GSTN 1, first thing is, Maloj, that GSTN is not a party. Maloj, the second thing is that the screenshot they have annexed at page 31 is not of the portal, my lord, it's of their own desktop. At page 31, the screenshot is of their own desktop, it's not of the portal.
At page
31, my lords, annexure 8.
No.
That is why probably, my lords, on the last occasion, a direction was given to file a supplementary affidavit because that GST ITC 1 is also not on record. Para 9, my lord, they have stated that there was some problem in the portal in uploading the said form.
Your client is continuing in the capacity of a composition dealer, obviously.
Exact position is not known to me, Your Lordship. He wants to engage some other lawyer. That is why I am saying one indulgence may be given to him so as to engage someone, Your Lordship.
My lord, it would probably not be a composition dealer, my lords, because its regular registration certificate has been granted on 17/7/2018 as per paragraph 7. Permission was granted on 17/7/18.
Supplementary affidavit has not been filed even after 1 year.
By way of last chance, Your Lordship, it may be fixed after any day, Your Lordship, after 10 days, Your Lordship.
Granted on 15th March 2021. Stop. And counsel for the petitioner, by way of last indulgence, seeks 1 week more time. Stop. seeks 1 week more time. By way of last indulgence, 1 week more time is allowed. Stop. Place the case in the week of 5th April 2022.
Item-
State Mr. Salman.
But I appeal
Item
to number 1.
The PS Pati for CGST.
Item 9, first appeal number 20 of 2021. Mr. Naveen Kumar Jaiswal for the appellant, Mr. Anurag Kashyap for the respondent.
May I please, Your Worship? On the previous occasion, notices were sent, or perhaps the opposite file respondent has appeared, Lordship, in this case.
I'm on the respondent side, my lord.
So, both the parties are ready to go for mediation.
My party is ready to go for their belongs from Jamshedpur, so it may be sent to the DLSS Jamshedpur. If possible, in Ranchi.
Mediation must have been held at DLSA Jamshedpur during pendency of the.
No, he has not. He has not received the notice. That's why this judgment is ex-party judgment.
Okay.
He could not appear there. That's why mediation has not taken place.
They are from East Singhbhum. Let them come to Jalsa and participate.
Yes, Lordship, no problem. He will come.
Wife has got a divorce.
Wife has got divorce. He has filed. They are residing in the same house still. The husband is his government employee, and they are residing there. So file की थोड़ा पीता होता था जज. That's why she filed the application, and he
They
did
are
not.
separated from 10 years.
Yes, learn counsel for appellant.
Yes, Lordship.
Oh, so for respondent, she is appearing. Shalaka
She is appearing on behalf of respondent.
Yes, Ms. Salaka, what do you have to say? Your party
No
is ready
issue.
to attend mediation.
Yes, my lord, no
At
issues
Jalsa,
with the mediation.
respondent has entered appearance. Respondent husband has, wife has entered appearance on notice through learned counsel, Ms. Salaka Srivastav. Stop. Then counsel for the respondent is, then counsel for both the parties agree that an effort for amicable settlement of the dispute may be explored through mediation at Jalsa at the appellate stage. Stop. Parties are from East Singhbhum, from Jamshedpur, and are ready and willing to attend mediation physically at Jalsa. Stop. The respondent wife has got an ex parte decree of divorce in her favor by the impugned judgment. Passed by learned additional principal judge, additional family court, Jamshedpur. Stop. In that view of the matter, let the parties appear before the learned member secretary Jalsa on 29th March 2022 at 10:30 am. Learned member secretary Jalsa can also be approached on the following numbers. On their appearance, matter be placed before the learned mediator for undertaking the exercise. Stop. Parties should attend the mediation proceedings with an open mind and attend each of the sittings. Appellant husband shall pay a sum of rupees 1,250 to the respondent on each date she attends the mediation in the presence of learned mediator Jalsa towards travelling and incidental cost. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. The matter be listed in the week of 9th May 2022 along with the report.
Item number 10,
Oblige, my lord.
WPC number 257 of 2021, along with item number 11, Ms. Amrita Sinha for the listener, Mr. P.S. Pati, Mr. Ashok Kumar Yadav for the respondent.
May I please, Your Lordship?
petition. Do petition. It's a very belated cause of action.
Yes, Your Lordship. In this case, what happened, Your Lordship, in the year 2006, when I filed
Time
my,
barred. Time barred.
Your Lordship, for the reason why I'm saying it's not a time bar, Your Lordship, in the year 2015, till the year 2015, they kept on making an inquiry in this regard whether the refund is liable or not, and they kept on making an.
Who prevented you to approach and invoke your remedy? There is a limitation under the statute of 3 years, or how much? What is the
That was,
limitation?
the limitation is with respect to filing of the refund application, and the refund application was filed within the period of 3 years. That was immediately filed within the period of 2 months itself, Your Lordship, from the date of the impugned order.
They have referred to the Articles of Limitation Act also, apart from the statutory limitation.
Your Lordship, in the writ petition, the article of the limitation
No,
137 is not
just to
particularly.
make the point stronger, that the delay is so huge that even the Limitation Act would not permit such kind of a prayer.
Yes, Your Lordship, there is a delay. I won't deny the fact that, but the fact is that till 2015, from the period 2006 till 2015, the delay was on the part of the department. They kept on making the inquiry. They kept on taking records, and they were not refunding my amount, Your Lordship, which they are not denied in the.
Is it possible, Mr. Who is appearing? Mr. Mittal?
Yes, madam.
So both of you are appearing.
My lord.
That you have also taken an objection that the application was made before Assistant Commissioner instead of the prescribed authority, Joint Commissioner. So, is it possible to entertain an application before the Joint Commissioner now, if liberty is given to them?
But there is one difficulty. Now, the case of the petitioner, what I understand is that some amount of TDS were not rightly taken into consideration by the assessing officer. Now, thereafter, the proper recourse available to the petitioner was that he should have filed an appeal at that point of time, because there is no notice of excess demand. For a refund application, a notice of excess demand is required to be there. That is not there. So, in any case, the entire exercise undertaken by the petitioner was futile. My lord, we have quoted the rules, required rules and statutory provisions. Once there is a notice of excess demand, then the application for refund is made. And when that refund application within the time frame is not disposed of, then the assessee is entitled for interest. So that situation never arose in this case. There is admittedly no notice for excess demand.
Your Lordship, they are not denied the amount.
Not have been challenged at that point of time itself.
Well, in fact, in the application for refund, you have to give the reference of the excess demand notice. In the application for refund itself, you have to say which excess demand notice is there as per which you are claiming refund.
What Mr. Mittal is saying, adding to that, assuming that there was some error, the assessing officer, assuming has committed some error in not taking into consideration the amount of TDS, then the option would have been at that point of time to file an appeal saying that this has wrongly been rejected, you allow it. Then that would have been allowed, and an notice of assessment order would have been passed. There would have been an excess demand showing in favor of the petitioner, and then thereafter followed by a application for refund. That is not there in this case. Now the petitioner is saying that some amount was wrongly not taken into consideration. I made an application, they verified, they ought to have refunded. How can they refund it? There is no notice of
Submit, Your Lordship, in this regard.
Yes, you will get a chance to respond.
Yes, Your Lordship. The assessment order was made on 7/7/2006, wherein a demand was ascertained to the extent of rupees 12 lakh 94,914. We don't have any objection with respect to it. We admit the assessment order. When the demand notice was issued, wherein only TDS amount was adjusted. However, the admitted position is that I paid certain amount with respect to advance tax also, and that fact has duly been verified by the authority concerned, and he has not raised any objection. Even in the counter affidavit, they are not denying the fact that an excess amount of by way of advance tax was duly deposited by the petitioner. So far as interest part is concerned, I may be, if there is any latches, that interest part may go, but my excess payment that is there with the department, that cannot be retained by them, your lordship. And thereafter they duly verified each and every fact. Time and again they verified from the treasury officers that whether an amount of rupees 4,50,000 has excess been paid by way of advance tax or not. That fact was ascertained by the treasury officer, that white check number so and so, entire detail is there in the treasury officer record, that this amount, if there was any defect in my refund application, they would have right away rejected my refund application. Now this particular stand is being taken only by way of filing a counter affidavit. Earlier this stand was never taken by the department. The department never rejected my refund application. They kept on verifying the fact. They could have, if there was a lack of jurisdiction, they could have transferred to the proper authority. They didn't do. They invoked the jurisdiction. They entertained my refund application. They made an inquiry with respect to whether the amount is paid, and it was ascertained by the treasury officer that yes, an amount of rupees 4,50,000 has been paid by way of advance tax. The detail is there at page 27. Then thereafter, in order to linger the matter, they did not pay, and then thereafter. I was not at all aggrieved by the assessment order, Your Lordship. The assessment order has duly been accepted on my part, and even that our order has attended the finality. Neither the department challenged it, nor we have challenged it. The assessment order has duly accepted, and it is a fact. They are not denying this fact that an excess amount has been paid by us. They made an inquiry. They came to the conclusion that yes, an amount was duly deposited. They in their demand notices, they have also allowed adjusted my TDS. Now in order to linger, they again verified my TDS payment with respect to my work contractor. They wrote a letter to them. It was ascertained by them also that yes, an amount of TDS has been paid. The entire TDS certificate also been annexed herein. Again they verified the fact, and it came to the conclusion that yes, an amount has been paid by him. Their grievance may be of the interest, that there is a huge delay, or maybe interest will be. So I'm not claiming my interest part from the year 2015 itself.
Interest part could come only if a decision is not taken within 6 months of the filing of the application.
Yes, Your Lordship.
Now, you yourself have slept over the right. The main constraint for us to allow your prayer is the delay of 12 years in moving the court. This we do not want to set up as a precedent, because this will start happening, and this would be something contrary to what the law prescribes.
This cannot be done,
The
Your
law
Lordship,
prescribes
because
a limitation. You see, the law prescribes a limitation. There are umpteen number of judgments, even the recent one, which says that statutory prescriptions are not meant to be bypassed in exercise of 226.
may I submit in this regard, Your Lordship, there was no delay in making a refund application. Within 2 months, we made a refund application. On 9/11/2006 itself, we made a refund application. So there was also a delay on the part of the department. Sorry, Your Lordship?
You moved this court in 2021. That is the main delay.
But then within the period of 6 months, they have to pass an order. Either they could have rejected on the ground of jurisdictional error.
Then
That
you slept after 6 months, no?
So you slept, no? Your grievances were not redressed, but you slept over your right and remedy,
But your lordship,
and
the
that is the hurdle that your
But your lordship
petitioner
may
is
kindly
facing.
appreciate this fact that the refund application was filed in the year 9/11/2006. There is a period of 6
That
months.
we
If
have
they could have
appreciated.
rejected it,
That we have.
they could have rejected it. Then only my cause of action would arise that I could have challenged it, or I could have made a fresh application with respect to proper jurisdictional authority. They did not do that. They never did that. It was
So
not
you should have
like.
moved the court at that very time, no? Even now they have not done anything. You moved in 2021.
But yes, not in 20. Yes, your lordship. But they
Yes, 20.
take a step. They moved forward. They took a step with respect to verifying my refund application. So when they were taking step, there was no occasion to move before this honorable court because they were duly taking the step. In the year 2007 itself, they took the step with respect to verifying the fact. If the department was just sitting idle on my refund application, then I could have moved before this honorable court. But the department were taking step on my refund application. They were making inquiries, they were verifying the facts, they were doing their part. In the year 2007, Annexure 5, your lordship may kindly see the respondent number 2 has taken the step on my refund application.
That is also of 2007.
Yes, your lordship. So, if a delay, there is no bar. If a delay is there, I was entitled for the interest. But they took a step in this regard.
Lord,
And
Lord, may I?
your lordship, that is my amount which has been excessively paid. Either it can be adjusted from the dues, if any, or it can be refunded back.
My lords, I may crystallize my submissions, my lords. My lords, the first, of course, is my lords of delay and latches. My lords, in my case, which is the serial number 11, my lords, the refund application is in 2008. There is a delay of 12 years, my lords, and there is not even a modicum of explanation in their writ petition, my lords. They say that the department has verified it. Even the verification was done in 2015. Then also, my lords, 3 years have elapsed. My lord, I sent a recent judgment, my lord, to the Supreme Court that mere filing of representation, which they have done in 2019, will not extend the limitation period. Again, my lords have sent a judgment of 1998 that refund application should be made within 3 years. My lords, my second point is, my lords, that even the refund application, there's no excess demand notice, therefore, the refund application itself was not proper. My lords, the third point is that they could have filed an appeal or a review against that assessment order read with the demand notice. And my lords, the fourth point is that it was filed itself before the wrong authority. My lords, if now they are given a chance to file a representation, my lords, again a fresh cause of action would arise. That is exactly what the Supreme Court says. That is exactly what the Supreme Court says. Because it says that such order shall not give an opportunity to the petitioner to thereafter contend that rejection has given a fresh cause of action. Because this is 2022 SCC Online SC 249 para 5. The first judgment, my lords. Surjit Singh Sahani, para 5. I have also sent a recent judgments delivered by my lords, and Rungta Mines that any application for refund has to be within the statutory limits. My lords have relied on the judgment of the Honorable Supreme Court in VKC footsteps. This is hopelessly barred by limitation, my lords. And my lords, if they are relegated by filing a representation, it would give rise to a wrong precedent, my lords, that a assessee can come anytime after 10, 15, 20 years and then claim a refund. If, my lords, if the department had been sitting tight, if it had not processed its refund application within 6 months, it could have come in 2008, 2009, 2010.
May I submit your lordship one thing? So far as the case of Mr. Mittal, the second serial number 11 is concerned, the assessment order itself dated 29/4/2008, and we made a refund application on 15/7/2008. So within a period of 2 to 3 months, and the section 42 of the Bihar Finance Act says that provided that no claim for such refund shall be entertained unless it is made within 3 years. So it was made within 3 years, rightly pointed out by Mr. Mittal that the refund application has to be made within the statutory period, and that was made within the statutory period.
That is
But
not my
before the
submission.
3 years, kindly allow me, Mr. Mittal, then you will be getting an opportunity. So it was made within a period of 2 months, and there is a provision, section 42 proviso says that within a period of 3 years. So there was not a delay of 3 years, Your Lordship. Within a period of 2 months, the refund application was made in both the cases. And so far as the judgment which has been relied upon by Mr. Mittal, in those judgment, for the 10 years, the petitioner had not made any application for the refund, and they directly approached the Honorable High Court for the refund, and they didn't took any step in this regard. However, this is not the present case. The present case differs. The fact of the present case differ from those facts.
Because it is not the refund application that is beyond the limitation. It is the writ petition itself which is. I'm not saying that the refund application is filed with delay. I'm saying the writ petition has been filed with delay.
They are continuously harping on my delay and latches, but they are not stating anything about their part. Continuously harping on my, yes, Your Lordship, there is
Your case, it was your claim. You should have. Why they will?
but they were taking the step.
Your case, you should have knocked the door in the year 2008 itself.
They were taking the step. For that reason only my client could not approach this honorable
For
court.
10 years, you were taking steps only.
This
last
fact is,
representation, last document where verification was done is of 26/10/2007.
2015, Your Lordship. 2015. That is 2015. That is dated 7/2/2015. Annexure 10 series.
Third learned counsel for the parties.
Okay.
Look at in WPT number 257 of 2021. In both the writ petitions, petitioner is seeking refund of an amount of rupees 4,26,173 with interest at the rate of 18% from the date of both the writ petitions relate to a claim of refund. Stop. In writ petition number 257 of 21, petitioner is seeking a direction upon the respondents to immediately refund the amount of rupees 4,26,173 with interest at the rate of 18% from the date of assessment order dated 7 July 2006, Annexure 2. Having claiming to have filed an application for refund on
In the first matter, it was on 9/11/2006.
9th January. In the index, you have stated 9th January.
It is 9th of November, Your Lordship.
9th November 2006. In the second writ petition,
it was done on 15/7/2008.
Petitioner has sought refund of an amount of rupees 9,69,405 with interest at the rate of 18% per annum from the date of assessment order dated 29th April 2008, passed by the 2008 stop. Both the assessment orders have been passed by the Deputy Commissioner of Commercial Tax, Palamu Circle, Altenganj. Stop. In the second writ petition, the application for refund was made on July 2008, Annexure 5.
15th July.
15th?
Yes,
Is
sir.
it 15th?
Yes, sir.
15th July 2005. पहले वाले में next year 4. Stop.
15 July 2008, not 5.
8, sorry. 15 July 2008 and next year 5. Stop. Learned counsel for the petitioner submits that the refund application has been kept pending till date despite reminders made by the petitioner such as annexures
Annexure 7 and 8 series. 7, 8,
and 8 series in the first writ petition.
7, 8, and 12 in the first writ petition, and in the second writ petition,
Annexure 9.
also
6 and 9.
7, 8, and 12 in the first writ petition dated so and so. 15 July 2008, 6 March 2009, and 14th May 2019. Stop. In the second writ petition, such reminders were sent on
6/3/2000.
6 March 2009.
Yes, my lords. Annexure 6.
And again,
And again,
14th May 2019, annexure 9. Stop. And counsel for the petitioner further submits that the respondent department was undertaking inquiries on the claim for refund, as would appear from letter dated 15 January 2015, exchange issued by respondent number 2, and further letters dated 7th February 2015 and 14th February 2015 by the same respondent, which certify that respective TDS amounts were deducted from the books of the petitioner and deposited by way of book adjustment with Accountant General Jharkhand. Stop. In the second writ petition, also similar inquiries were being made as per letter dated 15 January 2015 by the respondent department to the executive engineer, and the reply by the executive engineer REO Works Division, Garhwa and Daltonganj, dated 7th February 2015 and 29 June 2009, certifying that the respective TDS amounts were deducted from books of the petitioner and accordingly deposited by way of book adjustment with AG Accountant General Jharkhand Ranchi. Stop. However, instead of making the refund, the respondent sat tight over the matter, compelling the petitioner to approach this court in the present writ petitions. Stop. Therefore, there is no deliberate laches on the part of the petitioner in filing the refund application and pursuing his claim. Stop. The respondents cannot keep the refund application pending and still oppose the relief prayed for in the present writ petition. Stop. Learned counsel for the respondents have Mr. P.S. Pati state Mr. P.S. Pati and Mr. Salona Mittal, AC to GA1, both have taken common grounds in opposition to the prayer. Stop. Counter affidavit has been filed in both the writ petitions. Their objections are as under. 1. That the writ petition is barred by huge delay and lapses of about 15 years in the first writ petition and 12 years in the second writ petition, for which no explanation whatsoever has been given. Stop. 2. उसी में जोड़ दीजिए. Learned counsel for the respondent, relying upon the judgment of the apex court in the case of Union of India versus BKC Footsteps India Private Limited, reported in 2021, SCC Online, Supreme Court 706, submitted that refund of taxes is neither a fundamental right nor a constitutional right, but always a matter of statutory prescription which can be regulated by statute subject to conditions and limitations. Stop. Appellant, a petitioner, claim it as a matter of right after such huge delay. Stop. Second. No excess demand was raised in favor of the petitioner in form
15.
15. After the passing of the assessment order, for the petitioner to claim a refund to the prescribed authority in terms of section 42 in the prescribed form Roman 20. Stop. If the petitioner was aggrieved by the assessment order not determining the excess tax paid, it was open for the petitioner to go and appeal, which he failed to do. Stop. 3. The application in question has not been made before the prescribed authority, which is the Joint Commissioner of Commercial Taxes, in terms of Rule 42C.
That's 42(1)(c), madams.
1C says the amount of refund exceeded rupees 20,000. Stop. It is further submitted that mere filing of representation does not keep the cause of action alive. Stop. Therefore, In this regard, he has relied. Learned counsel for the respondents have relied upon the recent judgment of the Apex Court. This is in decision of the Apex Court, reported in 2022, SCC Online, Supreme Court 249, in the case of Surjit Singh Sahni versus State of UP and others, para 5. Stop. Based on these objections, respondents have submitted that the writ petition is fit to be dismissed at the threshold without giving any further opportunity to the petitioner to pursue his representation, as such representation cannot give such representation, as filing of such representation cannot give rise to a fresh cause of action. Once the original cause of action is stale on account of gross delay and laches. Stop. We have considered the submission of learned counsel for the parties and taken note of the relevant materials relied from the records. Stop. We have also gone through the impugned judgment. We have also gone through the decision cited by learned counsel for the respondents. Stop. It is tried law that claim for refund is a statutory right prescribed with limitations and conditions laid down under the statute. Stop. In the present case, though such application was made before the respondents, but not before the prescribed authority in terms of the Act, and long back in the year 2006 and 2008 respectively. Stop. Mere delay in deciding the refund application did not did not make the cause of action alive for such a long period to seek remedy under Article 226 of the Constitution of India. Stop. Mere filing of representation also does not extend the period of limitation, as the aggrieved person has to approach the court expeditiously and within reasonable time. Stop. The Apex Court in the case of Surjit Singh Sahni has at para 5 held that if it is found that the writ petitioner is guilty of delay and laches, the High Court should dismiss it at the threshold and ought not to dispose of the writ petition by relegating the writ petitioner to file a representation and directing the authority to decide the representation once it is found that the original writ petition is guilty of delay and laches. Stop. No explanation worth acceptance has been given by the petitioner to justify the delay of 15 and 12 years in the respective cases for approaching this court. So both the writ petitions have been filed in January 2021 and December 2020 respectively. Stop. As such, this court is not inclined to entertain this writ petition on the ground of delay and laches. Writ petitions are accordingly dismissed.
Item number 30, WPT number 378 of 2021, Mr. Panjanidan Rai for the petitioner, Mr. Rajiv Ranjan for the respondent.
May I please, my lord, I appear along with Mr. Pandit Rai for the petitioner, my lord.
For the last 2 days, we were hearing your elder brother.
I am aware, my lord. I am aware, my lord.
Good. In fact, I got a bit confused when I pointed out to Mr. Kavin. He said that actually my younger brother was appearing in the last day.
My lord, now at least there is one difference that he does not have a mustache. Earlier, when Justice D.K. Jain was retiring in the Supreme Court, my lord, 1 week before his retirement, both of us were sitting in his court together. And Justice Jain said that 1 week before my retirement, the confusion is dispelled now that there are two, not one.
No, the difficulty gets more confounded because of the virtual mode. Because
yes, absolutely.
Physically, obviously, one is in a better position to recognize.
Yes. Lord, in this matter, your lordships had not given us leave to also file a written submission, a brief submission, as also, my lord, copies of case law. We filed a compilation, my lord, along with the written submission and the case law that we want to rely on.
Yes.
And pleadings are complete, my lord, and the matter is ripe for hearing. Now, my lord, may I just, give a brief background, my lord, and some dates and some documents before, my lord, taking your lordships into the legal propositions. Does your lordship have that compilation, my lord? That's a compilation of 440 pages.
Yes.
My lord,
the respondents also would not have given their written submissions, and the hard and copy both. My lords have it, I think.
My lord, we have not been served with the respondent submissions, unfortunately.
No, it has been served. It has been served with the petition on mail. Soft copy has been given. Has been given.
My lord, anyway, my lord, I'll start. My lord, if there is a need for in the rejoinder to address something new, my lord, we'll see.
Does my lord not have the respondents' notes written submissions also?
Yes, we have that. But there are, in fact, two on the part of the respondents. One, and the second one is an email containing certain attachment of decisions.
Yeah, same, my lord, the same. We have filed a hard copy as well as the soft copy.
So your email containing the attachment of 4 decisions have been marked to the counsel for petitioner, but your written submissions, that perhaps may not have been sent to the petitioner's counsel.
The respondents' written submissions along with the lords, there are 4 judgments we have referred to, and also enclosed the copy of the judgments. We have given it to the petitioners also.
The judgments we have, my lord, I'll request my friend to just send the written submissions once again to our counsel
Yes, it hasn't served. It has been, Lord, I can see, Lord, the mail.
That's all right, my lord. I just don't have a
January.
copy. Can I just request for a
8th
copy?
of January, Lords, we have served the mail.
Okay. All right.
Just a minute.
Kumar.
स्क्रीन क्यों ऐसा हो जाता है यार? ऊपर से देख रहा है कैमरा नहीं. Hello.
Yes, what we propose, Mr. Gulati,
Yes, my lord.
is that we hear you today and get a overview of the entire case, what you have set up,
Yes, my lord.
and hear the state on the next day. Written submissions in the meantime will also be sent to you, and we will have the benefit of your response also on the next date.
Sure, my lord. No problem. So, my lord, may I just first, my lord, give a brief background before taking your lordships into specifics, my lord. My lord, the petitioner is a beer manufacturer.
Yes.
And, my lord, it imports into the state of Jharkhand beer from other states, manufactured in other states. And under the Jharkhand Excise Act, the state is entitled to, my lord, levy duty both for manufacture within the state and a duty on the import of liquor into the state by way of a countervailing duty. Lord, as your lordship knows, that countervailing duty is really to counterbalance the duty which is, my lord, imposed on domestic manufacturers, and therefore, my lord, a non-discriminatory principle also applies in that sense. My lord, as far as the state of Jharkhand is concerned, my lord, respondent number 3, which is the Jharkhand State Beverage Corporation Limited, my lord, is the sole, my lord, repository of power to purchase from the petitioner. And therefore, they purchase and they keep it in a warehouse, my lord, the liquor which is duty-free. At that stage is our case. And only on the clearance from the warehouse is the duty ultimately crystallized and adjusted. That's how it works. Both for the purpose of state excise duty, which is on the manufacturer, as well as on the import, or it is on the clearance that the duty becomes crystallized, is our case. My lord, what happened was that, my lord, we have a supply agreement, which I'll refer to, my lord, shortly, on 1st of April 2019 with respondent number 3, which has detailed terms, my lord, which has the rights and obligations of parties, under which, my lord, we make a supply. My lord, it's clear that, my lord, as far as the respondent number 3 is concerned, my lord, we get paid, first of all, my lord, only for the liquor which is finally sold in the market, which is on clearance from the warehouse. Equally, my lord, we have to pay the countervailing duty to R3, which in turn deposits it with the state. The process is, my lord, that the duty is collected in advance, and ultimately, my lord, a true-up happens on the issuance of the alcohol from the warehouse. Whatever is the final duty, my lord, that gets ascertained at the time of issuance. If it is in excess, my lord, it is refunded. If it is short, my lord, we have to pay more. That is the process, my lord, and that is flows from the scheme of the act as well as from the Jharkhand liquor policy, my lord, that this is the process which is followed. In fact, my lord, that we can't even transport it, we can't get a transport pass until we, my lord, make an advance deposit. Now, my lord, on 15th of October 2019, my lord, there is a letter at A4, page 65, where, my lord, on account of, my lord, what happened in the previous season, the state asked us to supply, my lord, adequate quantities so that there is no shortage of beer in the state. And that letter is on record, on account of which, my lord, we ramped our imports into the state so that we are ready for the summer season, my lord, where the consumption of beer is at the peak. My lord, thereafter, your lordships knows that in March 2020, specifically on 22nd March 2020, a lockdown was declared, where, my lord, everything came to a standstill. And, my lord, with beer, my lord, what happens is that beer has a specific shelf life. And the shelf life is, my lord, again determined by the state under the excise provisions. And in Jharkhand, my lord, it is 6 months. Earlier, it used to be 1 year. And in different states, my lord, there is a different shelf life. It's not as if after 6 months, my lord, the liquor becomes unusable or unportable, or, my lord, it's still potable liquor, fit for human consumption. But nonetheless, by way of statutory fiat, a 6-month, my lord, shelf life is prescribed. Post expiry of shelf life, my lord, the liquor has to be destroyed. It can't be sent into the market because, my lord, it can cause damage to public health and it can be a nuisance, my lord. So it has to be necessarily destroyed. Now, my lord, when the lockdown happened, a lot of this stock, which was, my lord, to the tune of 17 crores, as far as we are concerned, the shelf life was fast deteriorating, my lord, and it was coming to an expiry. And we, my lord, made representations, and this problem arose because, my lord, the lockdown was throughout the country. This is not specific to only the state of Jharkhand. My lord, in other states also similar situations arose because no liquor was allowed to be sold anywhere, my lord. And some of the states, my lord, of course, obliged us and said that yes, if the beer is fit for human consumption, we will increase the shelf life. Why, my lord? Because ultimately, if a product is destroyed, it is wasted. It's a national waste. It's not just a loss to us. It is, my lord, it's a destruction of productive resources of the country, after all. So some of the states, my lord, did that and saved the produce, and, my lord, were also entitled to the excise duty or the countervailing duty, as the case may be, on such produce. As far as the state of Jharkhand is concerned, my lord, we got the beer tested on 15th of July 2020, and A6, my lord, we first of all filed a representation on A5, page 66 in March 2020 for increase of shelf life. We put in, my lord, we got the produce tested, and there are chemical analysis reports at A672, where, my lord, the beer was found to be satisfactory and therefore could have been used. Nonetheless, my lord, the state did not relent and said that we will not increase the shelf life. Consequent to that, we said that if the beer has to be destroyed, which in fact it has been destroyed, either directly, my lord, in the warehouses of R3, or, my lord, taken back by us and destroyed, our claim was that you are not entitled to retain the amount that has been paid to you in advance, because this is not liquor which has gone out in the market. And unless there is an issuance from the warehouse, there is no question of the completion of the taxable event, and therefore you are not entitled to retain this. Please refund us 1,53,68,480, which we have paid to you in relation to the alcohol that has been destroyed or has been ordered to be destroyed. My lord, we filed a letter. There has been no response on this from 2020 onwards, consequent to which we filed the writ petition saying that this is money which has been paid in advance and it is refundable to us. You cannot keep something which is not authorized by law, because a retention of that money would be clearly in contravention of Article 265 of the Constitution of India. And whether or not there is a provision for refund under the Act, if a money is not required to be retained by you, I can claim it back from you, is my case, my lord. So this is, my lord, the brief background of how the writ petition arises, and my lord, what I have to demonstrate before your lordships therefore is, on the contrary, my lord, the state has taken a stand in the counter affidavit that the moment the liquor enters the state of Jharkhand, the duty becomes payable because it is a duty on import. That's their case. And my lord, they have relied on certain Supreme Court judgments to say that duty becomes payable on import, and therefore whatever happens subsequent is of no avail at all. That's the state's case, my lord. Now, my lord, kindly just for background sake, some documents, my lord. Page A2, page 53 of the writ petition. Is the supply agreement, my lord. My lord, this is a detailed supply agreement which, my lord, takes into account the Jharkhand liquor policy. My lord, I only refer to some relevant clauses which may help your lordships, my lord, in determining the scheme of the act. Not that the act, my lord, has to be interpreted according to the agreement, but nonetheless, my lord, this is in consonance with the scheme of the act. My lord, if your lordship sees page 55.
55 of the writ petition.
Of the writ petition, my lord. My lord, this agreement starts at page 53. At page 55,
Yes.
my lord, clause 1 says that the corporation will determine the quantities of the liquor which have to be, my lord, sold. That's one. And, my lord, kindly see that the clause 2A, the distributor manufacturer shall bottle, seal, pack, load, transport, unload, and shall stack the liquor at the depots of the corporation at its own cost and risk. Therefore, my lord, I continue to hold the liquor in their warehouses at my cost and risk, and the purchase as such does not happen merely on the import. And I am not entitled to, my lord, sell the liquor directly into the market at all. Then, my lord, if your lordship says 2D for a minute, the manufacturer shall bear the transit losses as defined in clause 9 of the liquor policy. They shall not claim for shortages, if any, arising from the difference between the quantities as dispatched by it and stocks actually delivered at the depot. Once again, my lord, establishing that I remain in session of the stock, and the corporation washes its hands away to say that whatever happens in the interregnum, even despite the fact that the liquor would have entered the state, I have nothing to do with it. It's your risk, your cost. Then, my lord, if your lordships are pleased to have, my lord, at page 57, clause 5C, that I have to transport it under permit and passes, and under the policy, my lord, unless I pay the advance amount towards the countervailing duty, this pass cannot be issued. I'll show that, my lord, separately. And, my lord, clause E at page 57 is important. In case if change in the fee and duty structure, new prices shall become effective from the date of notification by the government, date of implementation approved by the CBL authority. And G, my lord, due change in the duty and fee structure, the effect of price shall be borne by the distributors. Again, my lord, indicating that everything remains in a state of suspension until, and it continues to be my risk, and the exact rate, and this is clear from the reading of the act itself, the rate itself of the tax or of the countervailing duty is determined only on a certain event. What I am driving at, my lord, is that under every taxing statute, there is a taxable event. And on the occurrence of the taxable event, the tax becomes payable, my lord. And it crystallizes. And there are certain basic ingredients of a tax which have to be known on the occurrence of the taxable event, which is, my lord, if it's an ad valorem tax, then the value has to be known. The person who is liable to pay the tax has to be known. The nature of the levy has to be known, and the rate of tax is to be known. Unless these four basic ingredients are, my lord, available on the occurrence of the taxable event, the tax cannot be calculated. And until all of these four events, which are, my lord, stated by the Supreme Court to be essential ingredients of a tax, are available, no tax can be levied. And till the time that these four ingredients are available, whatever is paid can only take the character of an advance, nothing more. The tax itself is not leviable. And your lordships will also bear in mind one thing, that in tax, there are two words which are commonly used in all taxing statutes. One is levy and one is collection. Sometimes used, my lord, in conjunction, levy and collection of a tax. Explained by the Supreme Court to say that these have different character. These words don't mean the same. The levy is the incidence and the collection is a separate event, and the collection can happen either precede or be subsequent to the levy. So what needs to be determined is, what is the point of levy? And if the point of levy is subsequent, all acts prior, if my lord, the produce itself is not available prior to the point of levy, then no duty can be charged or retained, even if it has been paid in advance, is our case. And until these four ingredients get crystallized, and what is that event is what your lordships will have to determine in this writ petition, whether it's the entry of the goods into the barriers of the state or the boundaries of the state, or is it from the issuance of this liquor from the warehouse, which is where, my lord, duty-free liquor is stored in the corporation's warehouse. That precisely is the question, my lord, that your lordships will have to address. Now, my lord, if your lordship sees point 6 of the agreement at page 57, the corporation shall pay the distributor or the manufacturer only for the stock sold. This is extremely important, my lord. The corporation shall pay the distributor or the manufacturer only for the stock sold from the GSBL BCL depot to retail outlets with a Jharkhand notification. So, my lord, my transfer to the corporation and when the corporation sells to the distributor or to the retailer is simultaneous. That is at the time of the issuance of the liquor from the JSBLCL's warehouse. Then, my lord, 6B says the corporation and distributor or manufacturer shall be liable to pay all license fees and all taxes as per the provision of the Bihar and Orissa Act and VAT at the rates applicable under the Jharkhand VAT Act. Kindly, my lord, also note one thing, that the countervailing duty or the excise duty are both indirect taxes. It is not something that I have to, my lord, put the bill from my pocket. And therefore, what happens is, my lord, that I collect, my lord, the corporation is the first person who pays it to the government. They collect it from me. And when, my lord, the stock is ultimately sold to the distributor, my lord, pays it to the corporation. And further, my lord, it gets reimbursed by the retailer, and ultimately, it, my lord, comes from the pocket of the consumer. This particular stock that we speak about, my lord, a refusal of refund leads to a tax being collected from me, as if, my lord, it's my liability. The consumer, there is no consumer. There is no alcohol which is fit for human consumption. And your lordships knows, my lord, under the synthetics and chemicals principle, state excise duty or countervailing duty actually is leviable only on potable liquor, which is fit for human consumption. A levy of a tax on certain alcohol which has become unfit for human consumption itself is not conceptualized even under the Constitution. Now, my lord, this is the agreement. My lord, in my respectful, my lord, submission, there is nothing else which is relevant here. Just for your lordship's, my lord, completion of facts, my lord, my representation to say that the lockdown has happened and all this is getting lost, my lord, that representation I have put on record at page 66. It's a representation, my lord, of 10th of June 2020. This is in the first phase of the lockdown where everything was completely shut. Where I am requesting the state that 1,84,752 cases of beer of 14 plus crores, my lord, this escalates to 17 crores later, is lying, and states like Maharashtra, West Bengal, Daman, Diu, Silvassa and Northeast states have already increased the shelf life from 6 to 12 months. Please also do so in this state. That's my representation, my lord, at page 66. Thereafter, my lord, I produced before them a chemical report. Your lordships are pleased to see one such report. My lord, report is not important, just kindly note the date, 15 July 2020 at page annexure 6, page 72. I produced chemical reports to say that the beer can still be used. Please do not get this destroyed. Otherwise, there will be a huge loss as far as I am concerned. My lord, there is no action taken, and therefore, my lord, I approached the Minister of Excise at page 80, annexure 7 series, my lord, on 28th August 2020 to say that 17 crores worth of material is lying. Kindly do something about it so that this is not destroyed. Please increase the shelf life to 12 months. And if you don't do it, kindly at least get my duty which I have paid in advance refunded to me. Thereafter, my lord, I raise a specific, I write to the Secretary, my lord, on 28/11/2020. That letter is at page 82. Where I specifically seek a refund of 1,53,68,480, my lord, at page 83, if your lordship sees, to say that this amount which has been collected by the state on alcohol which is no longer fit for human consumption and has to be destroyed must be refunded to me. My lord, I also say that this will lead to an unjust enrichment of the state because this alcohol is not coming in consumption in the state and you are going to retain something which is on stock which is liable to be destroyed. So these are the facts, my lord. Now, my lord, may I just show to your lordships, if your lordships were pleased to turn to my compilation, the scheme of the act to establish, and then, my lord, I'll state some propositions, my lord, which on law. My lord, the state is the ultimate regulator of all, my lord, activities relating to alcohol and exercises its regulatory power under Chapter 3 of the Act, which is, my lord, I put.
There is no reply or response on any of your representations.
At all. For the first time in the writ, my lord, they say that no refund, no question of refund because goods have been imported. This is a countervailing duty on import and therefore nothing is payable to you. Import has happened. And our specific case will be, my lord, that the import commences at the time of the entry of the goods, but import is a process. And, my lord, there are similar provisions under the Customs Act, where, my lord, goods come in. The only difference is there, my lord, it's the boundary of the country. And here, my lord, the connotation of import is that it's the boundary of the state. And insofar as customs law is concerned, my lord, earlier the view of the Supreme Court used to be the moment the goods enter the territorial waters of the country, there is an import. And therefore, there is a duty implication. That view, my lord, changed to say that no, the import may commence at the time that the goods enter, but ends only on clearance. And in relation to warehouse goods, that clearance gets deferred. And only once the goods leave the warehouse. So, my lord, under Section 68 of the Customs Act, there are similar provisions of warehousing, just like they are in the State Act here. And one more commonality is that the charge there, again, both in relation to warehouse goods under the Customs Act, is also deferred and the rate of duty is applicable only on the issuance from the warehouse or clearance from the warehouse. Equally like under the State Act. And explaining that provision, the Supreme Court has said that until the rate is determined, and that rate is determined on a particular date, which is the date of clearance from the warehouse, no question of a tax before that. So any changes which happen, the context has always been, what if circumstances were to change? What if the duty were to increase or decrease prior to that event happening? Court says the determining factor and the date will be the date on which the Act prescribes that the rate will be applicable. Because it's an essential ingredient of the tax. Unless that is determinable, no tax can actually be levied. That's the logic, my lord. Now, in this light, my lord, if your lordship sees.
So, simply because in the mechanism, you are a distributor or?
I am a, my lord, importer. I am an importer.
Importer.
Which is, my lord, yes. A manufacturer outside the state and an importer in this state.
So, under the mechanism, as per the line of reasoning that you are advancing, only in the present case where the advance tax has to be deposited or advance duty has to be deposited.
Yes.
The state has got an upper hand to deny the claim, though the incidence of the levy had not arrived at because of no clearance from the warehouse. There was no occasion.
Correct. And my lord, there are judgments which my learned friend relies on, again Supreme Court judgments, my lord, where my lord, the general perception is, my lord, especially in the context of central excise, and that is where, my lord, the confusion arises. Your lordship knows that under central excise, the taxable event was manufacture of goods. The moment the manufacture was complete, duty becomes leviable. Once the duty becomes leviable, the Act by its own defers the collection of the duty on the clearance. Lord, that's a very different kind of a situation. If the levy itself is deferred versus only the collection getting deferred, these are two very separate, my lord, legs. That the levy itself can get deferred or the collection can get deferred. Now, if the collection is getting deferred, then of course the levy is complete otherwise. No question of anything. Anything happens after the levy is complete, you are not entitled to anything. But if I am right in what I am saying, that the levy itself comes into play only on a particular event, then if something has happened prior to that, that must be taken into account for the purpose of levy. Because, my lord, on the date when the levy applies, you need all ingredients. You need the quantity of liquor, you need the value of liquor, you need the rate of tax on liquor to be able to calculate the tax. If the quantity itself is not available, it becomes zero, there is zero tax. You can't apply, the state can't apply a prior rate of tax or a rate of tax applicable on a prior date, prior to the date of issuance from the warehouse. So you can't take the quantity which was available at some point in time, at an earlier date, and apply the rate at a later point in time. That would be, my lord, anomalous in my respectful submission. All those ingredients have to be determined on the date of issue from the warehouse. And this is clear from the scheme of the Act. I'll show from the scheme of the Act, my lord, how this happens. And the Supreme Court judgments that have been referred to, my lord, although they are in relation to state excise, have not considered this view. To say that when, in the case of an import, is the import actually complete? They go on the simplistic notion to say that import has happened, without really considering the judgment under the Customs Act on import to say it's a process and starts and ends at two terminal points. You know, On the entry it starts, but only on exit from a warehouse it ends, have not been considered at all. And that's a consistent view, my lord, which has been taken. And there is no difference whatsoever. I'll show that the determining factor is on what date does the Act prescribe that the rate will be applicable. That will be the determinant to understand whether or not the levy has been postponed or not. Now, my lord, in this slide, may I request your lordships to just see, my lord, some provisions of the Act, to just see the scheme of the Act. My lord, I have put the provisions from page 14 onwards in my compilation. My lord, chapter 3 is the general power of regulation of the state. I won't trouble your lordships right now for that. My lord, section 15, which is at page 23 of the compilation, is the statutory provision for establishment of the warehouses. Section 15, my lord.
Section 15 at page?
At page 23, my lord.
20. Yes.
The excise commissioner may establish or authorize the establishment of warehouses. My lord, I'm sorry, I'm reading clause C of section 15. Establish the authorize the establishment of warehouses wherein any intoxicant may be deposited and kept without payment of duty. Then, my lord, a license is required under section 16 for depositing or keeping intoxicant in warehouse or other place of storage. 17, my lord, is important. No intoxicant shall be removed from any distillery, brewery, warehouse. My lord, warehouse is applicable to us, or any other place of storage, license, authorized or continued unless the duty, if any, payable under chapter 5 has been paid or a bond has been executed for the payment thereof. Therefore, my lord, the removal is the determining factor even under section 70 from the warehouse. Then, if your lordship turns to section, my lord, 27, which is at page 39. My lord, if your lordship sees section 27, an excise duty or countervailing duty, as the case may be, at such rate or rates as the state government may direct, may be imposed either generally or for any specified local area on any excisable good imported, on any excisable article imported. So, my lord, countervailing duty, it is, my lord, an admitted case of the parties, both parties, my lord, including mine, to say that it is leviable on the import of the excisable article. Then, my lord, if your lordship sees section 28, which is on the next page, page 40.
Yes.
My lord, subject to any rules made under section 60, clause 12, any duty imposed under section 27 may be levied in any of the following ways. My lord, that's at page 40, if your lordship has it.
Yes.
And your lordship will say, see, on any excisable article imported, by my lord, clause 1, by payment upon or before importation in the state or territory from which the article is brought, or by payment upon issue for sale from a warehouse established, authorized, or continued under this Act. And clause 2 is what applies, that it is upon issue for sale from a warehouse which is established, authorized, or continued from the Act. My lord, your lordships will turn over the page at page 41, my lord. There are two provisos which are very important. Provided, my lord, the first proviso, provided that where payment is made upon the issue of an excisable article for sale from a warehouse, it shall be at the rate of duty in force on the date of such article from such warehouse. So the Act, my lord, fixes that date when the rate will apply, and that is on the date of issue from the warehouse. And this, in my respectful submission, is going to be determinative on when the taxable event arises. And kindly see the second proviso that makes it even clearer. The second proviso says, provided further that in case of excisable articles imported or transported on payment of duty according to the provisions of subclause 1 of clause A or C. My lord, 1 of A said that you could pay it on import or before that. Your lordship had seen that. So if you have paid before that, what is the effect? Provided further that in a case of excisable articles imported or transported on payment of duty according to the provisions of subclause 1 of clause A or clause C of this section, the difference of duty resulting from any provision in the rates of duty subsequent to such import shall be realized from or credited to the account of the importing or transporting license according to the revised rate of duty, which may be higher or lower than the previous rate, and the calculation therefore shall be made on the balance stock of excisable article on the date of the revised duty comes into effect. So, my lord, if there was a change in the rate of duty, what will be the effective rate? It will be the date of issuance, and if you paid more or less, then you will be either entitled to a credit or you will have to pay up the balance. Again, clearly indicating that it is the date of issuance from the warehouse which becomes material. Therefore, my lord, in my respectful submission, that once the Act itself makes this as the material event on which the tax will be determined, then unless this date has arrived in relation to particular stock, unless the clearance has happened, there is no question of levying a duty and retaining it if it has been paid in advance. Lord, that is the short submission on first principles of the Act. Now may I request your lordships to see some judgments, my lord. Now, my lord, at page 89.
So just for our understanding, say by way of an example, hypothetical example.
Yes, my lord.
That a consignment of beer is imported, kept in the warehouse, shelf life 6 months. Say out of whatever manner in which the quantity is quantified, say if 500 cartons of that liquor or beer is possibly disposed of or cleared from the warehouse within the period of 6 months.
Yes, ma'am.
And the remaining 200 or 300 remains, and its shelf life expires because it has not been extended. What happens in that case? No
that is the exact case that, my lord, your lordships are dealing with today. That the entirety of in your lordship's example, the entirety of the 800 cases of beer have not got cleared and shelf life has expired and they have been destroyed. That is the exact case, my lord.
So I just leave aside the COVID example. I say
yes,
in an ordinary...
COVID is one thing, but I am saying generally also.
No. So what happens to the 300 bottles
They have
or
to be
300
destroyed.
cartons?
They have to be destroyed.
No, destroyed. And what happens to the advance duty that you have deposited?
My lord, in my view, it has to be refunded, or my lord, it has to be taken as an advance in the account current, and my lord, adjusted against other stock which is being cleared from the warehouse. And that becomes the moot question, my lord, because it's an important question, my lord, to be decided. That ultimately, if goods are not getting cleared in the market, then are you entitled to any duty at all? Because ultimately, this is a duty, my lord, on sale. It is on manufacture or import, but ultimately the event is on sale of alcohol which is fit for human consumption. The constitutional power itself is only for levy of duty which is fit for human consumption. Because the converse view would really amount to authorizing a levy on liquor which is not fit for human consumption.
So if that part is retained by the state government, it's an unjust enrichment.
It is, my lord, if I am right in my proposition to say that the
Or
import,
illegal retention.
yes, my lord, that it is something which is collected without authority of law. If the section itself, my lord, the charge does not apply, then any payment, my lord, withheld by them, which is beyond the charge. Your lordship will recall I argued one case before your lordship. My lord, Justice Singh was party to the author of that judgment, my lord, in WS Retail, where, my lord, some amounts had been paid ad hoc by these e-commerce companies, and there was no liability. State admitted there is no liability, but they refused to refund. Your lordships, my lord, have relied on several judgments we had cited, my lord, on Article 265 to say that whether or not there is a provision of refund, if there is no liability under the Act, you cannot retain it.
What does the state say in the...
The state says, my lord, that the import has happened and therefore the duty has become final and no question. So the destruction of the stock is a post facto event after the levy has come into play. No question of refund.
No, what about the clearance part?
Clearance, they say that the duty is on import and therefore import happens, then my lord, they don't take into account the provisions that I have pointed out to your lordships to say that the duty itself is leviable at a rate and on a date when the clearance from the warehouse happens. There's, my lord, no, they don't advert to that position. And neither, my lord, the Supreme Court judgments being relied on have considered a situation like this. That what was that event on which the duty itself becomes determinable?
So the levy is complete on import and only the difference of taxes has to be paid according to them at the time of collection.
That's their case. That's their case.
Clearance.
My case is that the duty cannot be levied until all the ingredients of the tax are determinable, and once the Act itself points to a particular date of determination, then before that there is no taxable event. It's not that the collection has been postponed, the event of levy itself has been postponed. And that's the material difference between the judgments being relied upon and what, my lord, I will show from the ones that I am relying on. The levy itself is on a later date. And if the levy is not complete, then I am right in saying that you have no right over this money.
Yes.
Now, my lord, if your lordships are...
Blank bag. Yes.
Lord, if your lordships are pleased to have page 89.
Yes.
Yes, my lord, this is the judgment of the Supreme Court. First judgment, my lord, where this position as to when the import is complete is, my lord, decided.
Which one?
Page 89, my lord, Kiran spelling mills.
Acha. Kiran's.
Kiran spelling mills. And here, my lord, interestingly, the argument of the SSC was that the goods landed in India, there was no tax. Later than
The audio is slightly feeble from your end. I don't know. Because of network at this end or that end.
my lord, am I any clearer now?
Yes.
Now,
My lord, the argument in that case was that the SSC contended that when the goods landed in India, there was no levy of additional duty. And therefore, my lord, they said that no duty should be payable just because on the date of clearance from the warehouse, there is a duty. So, SSC argued quite the reverse, unsuccessfully. My lord, kindly see that contention is noted at para 5. I need not read it. That contention is noted at para 5. The Supreme Court's finding at para 6 is important.
Yes.
Lord, para 6 at page 91. Attractive as the argument is, we are afraid that we do not find any merit in the same. It has now been held by this court in Hyderabad Industries that for the purpose of levy of additional duty under the section 3 of the Tariff Act is a charging section. Lord, section 3 is also a countervailing duty under the Customs Act.
Yes, yes.
Section 3, subsection 6 makes the provision of the Customs Act applicable. This would bring into play the provisions of section 15 of the Customs Act. And your lordship will just make a note. Section 15 of the Customs Act also provides that in case of warehouse goods, it will be the date of clearance from the warehouse on which the rate will apply. Just like, my lord, the proviso of section 28 here, section 15 also has the same provision under the Customs Act.
Yes.
This would bring into play the provision of section 15 of the Customs Act, which inter alia provides that the rate of duty which will be payable would be on the date when the goods are removed from the bonded warehouse. That apart, this court has held in C Customs Act at page 803 that in case of duty of customs, the taxable event is the import of goods within the customs barriers. So again, my lord, there again it was an import of goods. And just like in this act, it's import within the state. In other words, the taxable event occurs when the custom barrier is crossed. In the case of goods which are in the warehouse, the customs barriers would be crossed when they are sought to be taken out of the customs and brought into the mass of the goods in the country. So the assimilation of those goods into the mass of the country is the material event for warehouse goods. Admittedly, this was done after 4th October, as on that date, when the goods were so removed, the additional duty of excise under the said ordinance was payable on the goods manufactured after 4th October. We are unable to accept the contention of Mr. Ramachandran that what has to be seen is whether the additional duty of excise was payable at the time when the goods landed in India, or as he strenuously contended, they had crossed into the territorial waters. Import being complete when the goods entered the territorial water is the contention, which has already been rejected by this court in Apar. My lord, so earlier, my lord, view of the Supreme Court that import is complete when the goods enter the territorial waters was rejected in Apar. The import would be completed only when the goods are to cross the customs barriers, and that is the time when the import duty has to be paid, and that is what has been termed by this court in the Customs Act 1964 decision. The bill to amend Section 20 of the Sea Customs Act and Section 3 of the Central Excise Act at page so and so Sea Customs case has been as being a taxable event. The taxable event, therefore, being the day of crossing the customs barrier and not on the date when the goods had landed in India or had entered in the territorial water, we find that on the date of the taxable event, the additional duty of excise was leviable under the ordinance, and therefore the additional duty under Section 3 was rightly demanded from the appellants. So this, my lord, makes it clear that it's the Section 15 date, which is the clearance from the date from the warehouse, which is the material date for determining when the barrier is crossed. The next judgment, my lord, where Kiran spinning is further explained and further clarified is page 93. This is the case of Garden Sills Mills. Now, my lord, kindly have, my lord, page 93 at page 100, my lord, 3 paras alone are relevant. Para 16 to 18.
Yes, which one is the other citation?
My lord, this is at page 93, Garden Silk Mills.
Yes.
My lord, both these judgments of Kiran Spinning and Garden Silk Mills are 3 judge judgments, my lord. My lord, judgment starts at 93. Your lordships were kind enough to have page 100, para 16.
Yes.
The question as to whether the import is completed when the goods entered the territorial waters, and it is the value at that point of time which is to be taken into consideration, is no longer res integra. This contention was raised in APAR. In that case, the day when the goods entered the territorial waters, the date of duty was nil. But when they were removed from the warehouse, the duty had become leviable. The contention which was thought to be raised was that what is material is the day when the goods entered the territorial waters, because by virtue of Section 223, read with 227 of the import into India, had taken place when the goods entered the territorial waters. Following this decision, Bharat Surfactants and Dheeraj Lal Bora, this court came to the conclusion that in APAR, that the duty has to be paid with reference to the relevant date as mentioned in 15 of the Act. So that is the date which becomes relevant. Section 15, or in our case, the proviso to Section 28. It was further submitted that in the case of APAR, this court was concerned with Section 14 and 15, but we have to construe the word imported. Just like, my lord, what the department is arguing in our case, that the import has happened and duty is on import. Imported occurring in Section 12, and this can only mean that the moment the goods have entered the territorial water, the import is complete. We do not agree with this submission. The court, in its opinion and bill to amend so and so, observed as under. Truly speaking, the imposition of an import duty by and large results in a condition which must be fulfilled before the goods can be brought under the customs barriers, that is, before they form part of the mass of the goods within the country. So unless, my lord, the goods are released into the country, the import is not complete until they become part of the mass of the goods of the country. It would appear to us that the import of goods into India would commence when the same cross into the territorial waters, but continues and is completed when the goods become part of the mass of the goods within the country, the taxable event being reached at the time when the goods reach the customs barriers and the bill of entry for home consumption is filed. My lord, in the case of warehouse goods, bill of entry for home consumption is filed only from the clearance of warehouse. And that is why section 15, my lord, clause 2 says that it is the date of the clearance of warehouse which becomes the date on which it will be applicable. Now, my lord, the next judgment, if your lordship sees at page 108, this is a case under state excise.
Page 108.
Page 108, this is a Karnataka High Court judgment. And here, my lord, under the rules, in our case, my lord, the proviso itself defines the date when the rate of duty will apply. Here it was under the rules. And the date of duty, my lord, under rule 2, which is, my lord, at page 111, was from when the goods were issued from the distillery or warehouse, just like in our case, my lord. My lord, rule 2 of the Karnataka excise rules is extracted at para 13 at page 111. Page 111, para 13 is rule 2. And your lordship will see in clause B, it is on when it is issued from the distillery or warehouse. Now, the discussion of the case, my lord, starts, the findings of the court are from page 115. 115, my lord, para 27.
Okay.
My lord, the court says that section 22, which is the charging section, by itself does not complete the charge, as the rate of duty is not prescribed in the section, but is prescribed by the state government. It is for such prescription that the rule is framed, and the rule also in turn links the levy to clause B of rule 1 of rule 2 of the rules. That is, the article manufactured, article issued from any distillery, warehouse or other place, or storage established or licensed in the state under which under any of the provisions of the Act. Of course, the rate is provided in the schedule, which is again scheduled to the rules and not to the Act. In other words, the charging section will be complete only when it is read with rule 2 and the schedule thereto, and not otherwise. One cannot reach the schedule without going through rule 2, and if rule 2 is one supplementing the charging section for effectuating the charge, the manner of levy as prescribed under rule 2 cannot be ignored, even for such purpose. The condition as stipulated in clause B of sub-rule 1 of rule 2 of the rules is very much part of rule 2, and is one which has to be necessarily taken into consideration for the purpose of completion of charge. If one were to read the section, rule and the schedule together, the charge is complete only when the manufactured article is issued from any distillery or factory and not otherwise. For reasons best known to the lawmakers and the rule framers, the charging section is made operative only at the issue point and not at any time earlier, though if the rates would have been provided independent of the rule and with reference to section 22 of the Act by a prescription in this regard by the state government, the charging section would have been complete or effected even without the manner of stage being reached in terms of rule 2. Then, my lord, kindly see para 32. It is in this regard that the decisions of the Supreme Court are relied upon by the learned additional government counsel in R.C. Jalparsi and in Sea Customs Act that throw some light. While it is a fact that the statutory provision and the liability has arisen, subsequent development in any way cannot detract for absolving any person of such liability, and is the principle declared in R.C. Jalparsi. And by applying the principle of this decision, if the charge should have been complete on the manufacture of potable liquor, it could have been certainly relied upon, even assuming that the recovery point had been postponed or deferred to a later stage, and the demand in terms of an extra J could have been sustained. Unfortunately, I find that the charging section remained incomplete without the aid of Rule 2, and the schedule appended to the rules, Section 22, remained incomplete without the rate being prescribed, and the prescription of the rate again being linked to Rule 2 of the rules, the schedule itself being in the context of Rule 2, there is no escape from the language of Rule 2. And therefore, my lord, the proposition that I am stating is that the charge is not complete until the rate can be applied, and the rate is applied only on the date of issuance. My lord, the next judgment of the Supreme Court is at page 119. If your lordships were to see para 6, my lord, your lordships has the SCC, my lord, citation. SCC. Para 6 of the SCC, my lord. Page 123, my lord, para 6. No, 124. Para 6. Para 6. We have heard counsel for the parties in support of the respective cases. In our view, the contention canvassed on behalf of the revenue cannot be accepted. The reasons are obvious. It has to be kept in view that the charge under the Central Excise Act fastened on a manufactured item once manufacture takes place. But the liability to pay duty thereon will have to be decided in the light of the appropriate tariff applicable at the time when such manufactured commodity is cleared by the manufacturer as per the provisions of the rules. It therefore becomes obvious that the duty becomes payable on a manufactured items once it is removed from the place of manufacture for consumption, export, or manufacture of any other commodity in or outside the place. Then para 8, the conjoint reading of Rule 9.1 and explanation makes it clear that if a manufactured item covered by the charge of excise duty by the charging provisions of the Excise Act is captively consumed, it would amount to removal of such manufactured item. Consequently, once the yarn is manufactured in the weaving department of the composite textile mill and is taken to the spinning department for captively consumed by way of consumption in the spinning department and gets consumed, it is deemed to have been removed within the meaning of Rule 9.1. Once that happens, the liability of such manufactured yarn to pay excise duty at the prevalent rate of duty is crystallized. Well, this is important. The duty gets crystallized only when the rate applies. After that, my lord, whatever happens, the next two lines says, after that, whatever happens is irrelevant. But the crystallization of duty is important. Then, my lord, the next judgment, Orient Paper Mills, at page 127. Here again, my lord, the issue is, the issue always arises when there is a variation of rate, my lord. Again, everything was complete, my lord. The goods were loaded in the wagons were, my lord, ready, and some change happened. Here, my lord, again, my lord, if your lordship sees para 10 at page 130, the dispute shortly stated is, as to the application of the two parts of Rule 9E. According to Mr. B. Sen, for the appellant company, the first part applied where the duty is paid and the goods are cleared. In such a case, the critical point of time is the payment of duty, and the point of time of removal from the factory is not relevant. In the second part, according to him, the critical time is the removal of goods from a factory or warehouse without payment of duty. Such happens when they are removed under provisions of 9A. Well, that is not relevant for us. Kindly come to para 12. It will thus be seen that in the case of manufactured goods, the payment of duty and the clearance of goods may be synchronous, or the payment may be postponed although the goods may be removed, proviso to 9. Now, my lord, this is the distinction. Is the payment only being postponed, or the levy itself is not determinable? This immediately sets up two kinds of cases in respect to manufactured goods. The critical time thus becomes the removal from the factory or the warehouse, but if the payment is made before the removal, then the critical time is the payment of duty. In the present case, the payment of duty was synchronous with the clearance of the goods because the gate pass can only be issued when the goods have actually been cleared or removed. The above construction. So, my lord, the proposition is that if on the date of payment everything is final, then of course taxable event has occurred. No difficulty. But in the construct of, in the manner in which our section reads, my lord, the payment is irrelevant. The actual rate, even if a payment is made on a particular basis, will be on the date of issuance. Then the levy itself crystallizes on that date. There's a difference. A statute can say that I say that you will make a payment, the date of payment or the date of clearance. Those can be two determinate events on which the duty will be applicable. If you made it on the date of payment, then that will apply. Or if you make it on the date of issue, that will apply. Both are taxable events. That would have been a very different case. And that is the case of Orient. So in Orient, my lord, finally, they say that everything was done on the date of payment and it was synchronous with the date of clearance. And therefore they said that whatever has been paid in excess, we will grant the refund. In our case, my lord, clearly the Act provides that even if you have paid it in advance, it has to be determined on the date of issuance. Now, my lord, the next case, if your lordship sees, page 132, para 3 is all I want to refer to.
क्रिस्टलाइज होता है वो स्टेट और वो चीज हम इस केस में हुआ ही नहीं सिंस इट हैज नॉट बीन हियर नॉट बीन क्रिस्टलाइज्ड उस पॉइंट को कहा
Yes.
Now, my lord, the next one, my lord, Dheeraj Lal Vora. My lord, this is for the proposition that you have to construe the date on which the duty is liable according to the provision of the Act alone. Now, just para 3 at page, last 7-8 lines of para 3, my lord, at page 136. First, fourth, my lord, I think I have a, my lord, different version of this, my lord, your lordship has the SCC.
Yes, SCC.
My lord, I have the ELT citation. My lord, I'll just tell your lordship where I am referring to.
Para 3 starts from, it is clear from a bare reading of these.
That is right. That is right, my lord. In this para, my lord, the last, my lord, the sentence starting from therefore the relevant date under section 15(1)(a). My lord, this is placetum F of the SCC. Placetum F in the SCC, my lord, page 135.
Therefore.
Yes, the last word, therefore. Therefore, the relevant date under section 15(1)(a) is the date on which entry inwards and delivery of import manifest was granted to discharge the cargo for the purpose of levy of customs duty and the rate of tariff. The contention, therefore, that the ship entered the territorial waters and was ready to discharge the cargo is not relevant for the purpose of section 15 and 46 and 31 of the Act. The prior entries regarding presentation of the bill of entry for clearance of goods and the receipt in the appraising section of section 28 are irrelevant. The relevant date to fix the date of customs duty, therefore, is March 2, 1989. The rate prevalent as on that date would be the duty on which the goods imported are liable to be imposed, and the goods would be cleared on the payment in accordance to the level. So, my lord, section 15 encompasses under the Customs Act several dates. This is a case where there is a prior bill of entry, even before the goods enter. So the court says that whatever is the prescription under the act of the relevant date, you will take that into account and pay duty according to that. So how the act is constructed is what is material. Now, my lord, the next judgment, page 138, Govind Saran Ganga Saran. Now, my lord, this is a general proposition that I wanted your lordships to consider, that the essential elements of the tax, there are four essential, my lord, which I said in the opening, four essential elements of the tax. Unless they are determinable, the question of the taxable event arising does not, my lord, happen. Para 6, my lord, your lordships will see at page 142, the last line of page 142. The components which enter, my lord, page 142, para 6, the last line.
Yes.
The components which enter into the concept of a tax are well known. The first is the character of the imposition, known as the nature, which prescribes the taxable event attracting the levy. The second is a clear indication of the person on whom the levy is imposed and who is obliged to pay the tax. And the third is the rate at which the tax is imposed. And the fourth is the measure or value to which the rate will be applied for computing the tax liability. If those components are not clearly and definitely ascertainable, it is difficult to say that the levy exists in point of law. Any uncertainty or vagueness in the legislative scheme defining any of those components of the levy will be fatal to its validity. Therefore, my lord, if the rate is not determinable, the levy is not complete. These four essential characters of a tax need to be ascertainable, determinable for the levy to be complete, is the proposition I am canvassing.
No, but can it not be said that even on the date on which the goods entered into the territory of the state or said to have been imported, the rate of tax, a particular rate of tax was applicable on that date with which you have been charged to deposit the advance tax, and only at the time of clearance the state has made a stipulation that if there is any difference of rate, you will have to pay the difference.
That is why, my lord, it is the issuance which becomes the point of levy. So whatever has happened in the past, that therefore, my lord, I said that when do you calculate the tax? You have to calculate the tax on the date of clearance by multiplying the quantity into the value into the rate. Quantity at that stage is zero.
No, so on the date you have paid the advance tax, you must have calculated the quantity with some rate.
That is only in advance. That is what I say, my lord, that at that point in time, it is only the character of an advance. It is not really a duty which is determinable at that date. It's only an advance. An advance, my lord, payment is different from the levy itself. It rests with them as a deposit until, my lord, it is finally appropriated when the taxable event finally happens. And therefore the import has commenced, but it has not ended. My lord, may I just request your lordships
Yes.
to come back to page 91. Lordship's query is answered, my lord, in the Supreme Court judgment.
Yes.
My lord, para 6 at page 91, your lordships have seen. Just kindly read it again for my lord, my satisfaction, because this query that your lordships put, how will you determine the taxable event, is answered here, my lord. Kindly see, my lord, what this says, that in Hyderabad, that for the purpose of levy of additional duty, and the tariff charging section, section 3 of subsection 6 makes the provisions of the Customs Act applicable. This would bring into play the provisions of section 15 of the Customs Act, which inter alia provides that the rate of duty will be payable would be on the date when the goods are removed from the bonded warehouse. Well, exactly the position like ours. That apart, this court has held in C Customs at page so and so that in case of duty of customs, the taxable event is the import of goods within the customs barrier. In other words, the taxable event occurs when the customs barrier is crossed. In case of goods which are in the warehouse, the customs barriers would be crossed when they are sought to be taken out of the customs and brought into the mass of the country. So it is that. It's a question of determining the taxable event, and that happens only on clearance. It's not as if something else, my lord, just because you paid it in advance, that becomes a taxable event. When, therefore, my lord, do you construe the import to be complete, is the question. The import becomes complete only once you release the goods into the mass of the goods of the state. It becomes, my lord, available in the state for human consumption. And
Physical movement of goods within the boundary of this state after crossing the territorial limits of this state till it reaches the warehouse is no taxable event.
It's only commenced. The import has commenced. Certainly, it's commenced, and that is why, my lord, the second judgment in Garden Silk Milk, Supreme Court further clarifies that yes, the goods are in the country. My lord, once the goods come into the territorial waters, they are in the country. So the event has commenced, but has it ended? They say that it ends only. So so import is a process. So it has commenced, but it has not ended. It ends only once the goods get cleared.
Yes.
Now, my lord, page 147 is your lordship's judgment, my lord, in WS Retail, which I had mentioned.
Yes.
My lord, at page 148, your lordships have, while my lord noticing the arguments, noted all the judgments on Article 265, HMM, etc. And your lordship's findings, my lord, at page 150.
Yes.
After, my lord, relying on those judgments, your lordships have said, my lord, around 12, 13 lines, my lord, from the bottom of page 150, the claim of refund has been denied on the plea that there is no provision under the JVAT Act. Since the petitioner is not a registered dealer, no assessment proceedings have been held. Under the scheme of the JVAT Act, the assessment proceedings can be held against the dealers who have failed to get themselves registered. However, no assessment can be made under 3738 after 5 years from the end of the tax period to which on the face of the pleadings on record and the stand of the respondent brought through the counterfeit, rejection of claim for refund only on the ground that there is no provision under the JVAT Act for entertaining such a claim is not sustainable in law. Your lordship has noted all those judgments, my lord. Therefore, my lord, a plea is taken in the counter in our case also to say that there is no such provision for refund. If there is no levy, then whether or not there is a provision, you can't retain the tax or you can't retain the amount. My lord, the next judgment is of the Patna High Court when, my lord, prohibition came in. When prohibition came in the state of Bihar, my lord, a lot of stock of liquor was lying and it had to be removed. The question was, what will happen to the excise duty which would have been paid in advance if the goods are not cleared in the state of Bihar, ultimately. The court, my lord, came to the conclusion that you will have to consider, you cannot refuse to consider the applications for refund. And your lordship sees, page 176 onwards, my lord, some discussion. And here again, my lord, stock was being destroyed because it could not be sold. But on page 176, the state took the ground to say that we gave them enough opportunity to remove this. Much like, my lord, what has been pleaded here, that you should have removed it. So what if we didn't extend the shelf life? You should have removed it. Now that you have not removed it and it has to be destroyed, we won't refund you. Now, my lord, the last para at page 176, we are willing to agree with the contention of the petitioner that to the extent of 6 crore 73 for refund of excise duty paid on stocks lying on respondent number 4 and or the petitioner as on 31/3/2007 is required to be considered along with other claims on account of bottling and license fee which are deposited by the petitioner. Learned counsel for the petitioner has rightly submitted that the bottling and license fee would be payable on saleable stock of IMFL. And since the respondents have destroyed the stocks of the petitioner, they are not entitled to retain the bottling and licensing fee deposited for the goods. The outstanding claims as shown above in the table on account of excise duty 19C fees and bottling fee for the financial year 15-16, together with the carry forward license fee for the said periods for the balance period 16-17 are thus liable to be considered by respondent number 2. And my lord, the next page 178. Similarly, we are of the view that the Excise Commissioner of Bihar would be obliged to consider the claims of the petitioner on account of excise duty paid on stocks lying on with the respondent number 4 or the petitioner as on 31/3/2017, which were not or could not be exported during the available period. The respondent shall accordingly also be obliged to consider the other claims of the petitioner on account of bottling and licensing fee for the financial year 15-16, carry forward bottling and license fee for the financial year 15-16 and bottling and license fee for the so-and-so to the extent it has remained undecided. So, my lord, they sent it back for consideration. And again, on the same principle, my lord, to say that if it is not being sold in the state, then what right does the state have to retain this amount? But again, a ground is taken in the counter affidavit on alternative remedy to say that you are dealing with respondent number 3 and there is an arbitration clause in the agreement. My lord, I am relying on the Supreme Court judgment in Vidya Drolia, which says that, my lord, whether or not a tax is payable is not an arbitrable dispute. It's a sovereign function, and only a court can determine that. No arbitrator can determine whether a tax is payable or not. If it is not payable, then I have a right to invoke the writ jurisdiction of your lordships, my lord, to claim a refund, even if there is no provision for refund. My lord, only para 50 is relevant to say that sovereign functions are not arbitrable. Para 50 of this judgment on alternative remedy and
This
taxation.
Which judgment?
My lord, this is Vijay Drolia, my lord, page 202.
Vidya Drolia.
Oh, sorry, Vidya Drolia, page 202. Para 50 at page 262 is all, my lord, I want to rely on to say that alternative remedy can't come into play in a matter like this. Para 50, my lord. Para 50, my lord.
50.
50. Lord, this talks about sovereign functions of the state being inalienable and non-delegable and non-arbitrable, as the state alone has the exclusive right and duty to perform such functions. For example, it is generally accepted monopoly rights can be only granted by the state. Correctness and validity of the state or sovereign function cannot be made a direct subject matter of the private adjudicatory process. Sovereign functions for the purpose of Arbitration Act would extend to exercise executive power in different fields, including commerce and economic and legislation in all forms, taxation, eminent domain, and police powers, which include maintenance of law and order, and so and so. So, my lord, whether or not a tax is actually payable is not an arbitrable dispute at all. Now, my lord, just turning to, my lord, two of the Supreme Court judgments which my learned friends, my lord, rely on. My lord, if your lordship sees two judgments which my learned friends have relied on, S.K. Patnaik is the first judgment, and that's.
This is in your compilation also.
No, my lord, their compilation. They have
Yes.
sent those judgments by that email, my lord.
No, it's in our compilation, it's page 18.
Page 80.
18.
Yes, yes. Yes.
My lord, this is a 2000 judgment, also a 3-judge judgment of the Supreme Court. And, my lord, Kiran spinning as well as garden silk mills were already there at this time. Not noticed as to when is import complete. And if your lordship sees, this goes on the basis, my lord, that the levy has occurred under section 28, but the collection is postponed. My lord, para 5 of this judgment, my lord, the scheme of the act, the proviso, the second proviso, none of it is noticed in this judgment. The position in garden and Kiran is not noticed. And my lord, kindly see, and there is a contradiction in terms in para 6. Section 27 of the Bihar and Orissa Act deals with the powers of the state to impose duty on import, export, transport, and manufacture. The section, my lord, I'm at para 5 of this judgment.
Yes.
This section is the charging section both for excise duty as well as for countervailing duty. Section 28 of the Act, on the other hand, provides for ways of levying duty and can be imposed under Section 27. Section 28 deals with the manner of levying duty imposable under Section 28 in different manners. Though countervailing duty or excise duty is required to be assessed and collected as soon as taxable event arises, a facility for postponement of collection of excise duty is envisaged under Section 28 in case of sale of excisable article from the bonded warehouse after its import into the state. But it doesn't go into the question that when is import complete. And then kindly see para 6, the first two lines. While the expression levy may include the process of taxation as well as determination of the amount of duty, so the court, my lord, recognizes that the term levy includes the determination of the duty, which, my lord, unfortunately, if the proviso was not noted, it would have led to the conclusion that the levy itself is postponed. The expression collection refers to the actual collection of duty payable or the tax, as the case may be, says the taxable event for attracting excise duty or countervailing duty is the manufacture or import of articles into the state. The charge of incidents or stands attracted as soon as the taxable event takes place. Now, it begs the question, when is the import complete? And the facility for postponement of collection of duty under the Act or the rules framed thereunder can in no way affect the incidence of duty. In view of this, in this view of the matter, the demand for countervailing duty from the appellant in the established factual circumstances was perfectly justified. The fact that the liquor was rendered unfit for human consumption and destroyed after its import. Now, my lord, which by itself attracted the levy of duty, could not wipe off the liability. My lord, as a proposition, this is correct. I don't say that this is, my lord, incorrect in any way, but the first determining factor is, when is the import complete? The next judgment, my lord, is aristocrat.
Because that is at page 52 of our compilation.
Which follows, my lord, this S.K. Patnaik. Again, my lord, again the same, not same, but my lord, again a three-judge bench headed by His Lordship Justice Anand, CJ, again 2001, my lord. But S.K. Patnaik, my lord, is noticed in para 7 and para 8. And para 10, my lord, your lordships will see. That thus our answer to the question. What is the conclusion, my lord? Thus our answer to the question posed in the earlier part of the judgment is that the countervailing duty is chargeable at the rate prevailing on the date of actual import of the consignment into the state, irrespective of the duty as enforced at the time of obtaining the permit. Therefore, my lord, if I apply it to our facts and apply the proviso, then the date on which the duty is chargeable, which is the date of clearance, is alone relevant. And what has happened at the time of deposit or at the time of entry of the goods into the state is irrelevant. Is chargeable at the rate prevailing on the date of actual import, which in my case will be only from the date of clearance from the warehouse. Now, my lord, in this slide, may I just complete my compilation, my lord, because this was necessary to show to your lordships. My lord, page 364. My lord, 364 is also, my lord, para 52, if your lordship sees, that a question of determination of whether a duty is payable or not is not arbitrable. Para 52, Allahabad High Court.
Which page?
My lord, this judgment starts at page 364. Para 50 and para 52 at page 369. The question of whether statutory dues are payable or not is not arbitrable. My lord, assuming for a minute, my lord, that S.K. Patnaik comes, my lord, is a judgment, my lord, which can be applied. My lord, according to me, it cannot be applied because the scheme of the act is not noticed and binding judgments of the Supreme Court, earlier judgments are not noticed. Assuming, my lord, for a minute that your lordships are presented with two sets of judgments, my lord, like this, what is the view that your lordships should prefer? Two judgments, my lord, three judgments I will cite on that. My lord, page 370, judgment, my lord, says that if this is the situation, para 24, then the court is entitled to look at which is the better view to follow, which is a well considered. Para 24 of this judgment, my lord, this starts at 370. Your notices will come to page 379.
This is that Maharashtra judgment.
Yes, my lord. My lord, Justice Brahme and Justice Gawai, as his lordship then was.
Yes.
Justice Gawai's judgment, my lord, relying on a full bench, my lord, para 24 at page 379, if your lordship will come to.
Yes.
Para 24 at page 379, my lord. The full bench of this court in the case of Kamleshwar Ishwar Das Patel versus Union of India, dealing with the question as to what course is to be followed by the High Court when confronted with contrary decisions of the Supreme Court emanating from benches of co-equal strength, has held that the High Court is not necessarily bound to follow the decision later in point of time, but must follow the one which in its view is better in point of law. For coming to such a conclusion, the full bench of this court has relied upon the judgment of the Constitutional Bench of the Apex Court in Atmaram versus State of Punjab. We are of the considered view that the division bench of the court, in this case in Sanjay Panikar, has correctly considered the observations of the Constitutional Bench of the Apex Court in this last paragraph of the judgment in the case of Milan. This, my lord, and then, my lord, a full bench of the Punjab and Haryana High Court at page 381, my lord. Same proposition, my lord. I just request your lordships to note the para numbers. Paras 27 to 32 and para 37. Same proposition. And, my lord, a very interesting judgment of the Constitution Bench of the MP High Court, my lord, at page 395. Your lordship will just see the conclusion, my lord. The discussion need not be seen. That when there is, if there is at all a conflict, then the court says that it is the earlier view which should prevail, not the later view. Unless the later judgment has explained the earlier view. Lord, at page 440, if your lordship sees the second paragraph, case of conflict between two decisions of the apex court,
Para?
my lord, the last page, my lord, page 440. Paras are not mentioned. Page 440. Second paragraph on page 440. The last page of the compilation.
Yes.
The second paragraph. In case of conflict between two decisions of the apex court, benches comprising of equal number of judges, decision of the earlier bench is binding unless explained by the latter bench of equal strength, in which case the latter decision is binding.
Yes.
Therefore, my lord, in my respectful submission, if the import, so even S.K. Patnaik says that the duty is leviable on import if the import is complete only on the issuance of the warehouse, and in terms of the proviso, my lord, if the duty is actually, the rate of duty is determinable only on the issuance from the warehouse, then that becomes the taxable event. The levy itself is postponed, and it's not a case of collection being postponed on its own, where the levy was otherwise complete. In this case, therefore, an event has happened prior to the levy coming into force, and therefore, no duty is payable at all, and the amount deposited is liable to be refunded. Lord, I'll deal with my learned friends, my lord. I just got a copy of the compilation and their written submissions. My lord, if your lordships permit, my lord, I'll deal with it when your lordships hear the other side, my lord.
But we'll reply after the
yes.
their submissions.
Yes. My lord, I have summarized these submissions, my lord, in my written submissions also for your lordship's consideration. Cited all these judgments.
Yes.
My lord, those are my submissions.
The learned advocate general is on legs, my lord. That indicated that the date would be fixed where the learned advocate general's submission would be presented.
You can keep it on 7th April.
Yes, my lord.
Yes, sir.
Our contention would, of course, be that it is covered by S.K. Patnaik and that only the collection is deferred, but the levy is on import itself. That would be our contention.
Thank you, Mr. Land Counsel for the petitioner, Mr. Tarun Gulati, has advanced his submissions. The submissions on behalf of the state can reply by the petitioner, close the case on 7th April 2022.
My lord, is it possible for your lordships to put it on an online day, my lord?
I saw that, but perhaps we were already occupied on that day. Then 13th April is a better.
Yes, my lord, 13th.
13th April.
I'm obliged. Deeply obliged.
So we have left with the batch cases. Please celebrate. Mr. Kurni, you are appearing in the batch cases.
Yes, my lord, I am appearing in the batch case, my lord.
So we take up after lunch.
My lord,
Achha, there is a tied up bench also. Tied up पहले करके तब से बैठे. Very well.
प्रणाम, my lord.